Hi, students. I'm back. This is on Unit 8, corresponds to Chapter 8. Chapter 8 is right to counsel and pretrial identification. I'm going to cover right to counsel. It's week 13, and then next week, week 14, will be the pretrial identification portion. So when we talk about right to counsel, you'll find right to counsel in the Sixth Amendment. The right to counsel guarantees that in all criminal prosecutions, the defendant shall enjoy the right to have assistance of counsel for his or her defense. The right to counsel reduces the risk that the innocent will be convicted and aids the assertion of the defendant's constitutional rights. So let's talk about the development of the right to counsel historically here. So during the first 150 years, the right to counsel simply meant that a person could hire their own attorney, and the government could not deny that person of the ability to hire an attorney to represent them. So that was the first 150 years. And then along came a series of uh, um, cases that expanded the right to counsel. The first one that I want to mention is Powell versus Alabama. It was a 1932 case, U.S. Supreme Court, and the U.S. Supreme Court used the due process clause of the 14th Amendment um, to set aside a state felony conviction because the defendants were not provided appointed counsel. So remember, the due process clause of the 14th Amendment provides that a state cannot deprive a person of life, liberty, or property without the due process of law. The due process clause includes the substantive due process clause and then also the procedural due process clause. And in this particular case, they relied on the due process clause, procedural due process clause, that in this case required these defendants to have appointed counsel for their defense. The facts of this case were pretty interesting. It was happened in 1931. There were seven black kids on a freight train. There were also some white boys and white girls. A fight broke out between the two groups, and the white boys were thrown off the train. Then the white boys reported this to the authorities, and the authorities were waiting for the train at the station. The black kids were arrested and charged with rape of the girls, the white girls. So this happened, as you know, in Alabama and back in the 30s. So you can only imagine what it was like for these black kids to be charged with these crimes in Alabama. Uh, what was what was unique about these defendants is that they were all young, they were all illiterate. There was a tremendous amount of public hostility against them. In fact, they had to call out and rely on the military to protect them. Their families were out of states. They were in the in peril of their own life because of these particular charges. So they were denied counsel, and they were convicted, and then they appealed to the U.S. Supreme Court, and the U.S. Supreme Court said because of these special circumstances of these particular defendants, because they're of the things I just mentioned to you, uh, those were special circumstances that required appointment of counsel under the due process clause of the 14th Amendment. Along came another case, Johnson versus Zerps. That was a 38 case also before the U.S. Supreme Court. And in this case, the U.S. Supreme Court used the Sixth Amendment and required appointed counsel for an indigent or poor person facing serious federal charges. So they moved away from the due process clause. And the reason that they did that is because remember, in Powell versus Alabama, it was the special needs of these particular defendants that required appointment of counsel under the due process clause. So every time there was a case in court, they always argued before the court that, hey, my client has a special need, and pretty soon, it was almost everybody that needed to have an attorney appointed to represent them. So it became kind of difficult to really manage, appointed counsel in these cases. So the U.S. Supreme Court moved away from that and required appointment of counsel now under the Sixth Amendment, which I just read to you. And then along came after Zerps was a case called Gideon versus Wainwright. It's a 1963 case, U.S. Supreme Court case, and it held that the Sixth Amendment entitles an indigent defendant charged with a state felony with appointed counsel. Gideon is a very important case because there was another case before Gideon called Betts versus Brady. That was a U.S. Supreme Court case. And in Betts versus Brady, the court basically said when you have a defendant facing a state felony, that appointed counsel wasn't a fundamental right, and therefore it was the states could decide it. So the Sixth Amendment um, wasn't incorporated into the 14th Amendment and didn't apply to the states. It was really up to the states to decide if a person should have a lawyer, and the states just did not do that. So Gideon was charged with a felony in the state of Florida. He asked for a lawyer under the Sixth Amendment. The court said, no, you're not entitled to one. He represented himself. He was convicted. He ended up filing by himself a writ or appeal to the U.S. Supreme Court, and the U.S. Supreme Court overruled the Betts case and said, you know what, this is a fundamental right. Having a lawyer is a fundamental right. It is incorporated into the Sixth Amendment, and they reversed his conviction, sent it back down to the state court for trial. He was appointed a lawyer in his second trial, and he was acquitted. So Gideon is a very, very important case in criminal jurisprudence. You're going to be watching a video on the Gideon case. It's a very interesting and very important case. And after Gideon came along, another U.S. Supreme Court case, 1972, it's Argersinger versus Hamblin, which expanded Gideon to expanded Gideon to a person facing any incarceration. So in California, there's three categories of crime. There's an infraction, misdemeanor, and a felony. An infraction is punishable by a fine. That's like a traffic ticket. Because you're not facing incarceration, you're not entitled to a court-appointed lawyer. But you can hire your own lawyer, or you are free to represent yourself. So you have that choice, but you're not entitled to a court-appointed lawyer unless you're facing incarceration. Now, you are facing incarceration if you're charged with a misdemeanor or a felony. Therefore, if you cannot afford one, the court will appoint one to represent you free of charge if you can't afford it. Generally speaking, there will be a hearing either before or after appointment of counsel to determine your ability to pay. If you have the ability to pay for some or all the court-appointed lawyer, you will be required to make that payment. So another aspect of right to counsel, originally it only applied to trial. So you had the right to counsel, but it was only for trial. But the courts expanded that right to counsel to all critical stages of the criminal proceedings. So what's a critical stage? Well, a critical stage has to have three components. The first one, or first element, is the person has to be charged. Secondly, the person has to be present at the particular proceeding. And third, important rights may be lost unless the person has an attorney to represent them. So when you take those three elements and you apply them to our criminal proceedings, you'll determine that right to counsel applies to, first of all court proceedings. So all court proceedings. So when you stop and think about it, all court proceedings, let's say, for example, the initial appearance for a defendant is at the arraignment. So at the arraignment, the person will be advised of the charges, will be advised of their rights, asked if they want a lawyer. They'll set the next court date, and they will decide the uh, whether or not they will be held or detained pending their trial. So, so when you look at the right to counsel, is that a critical stage? Yes, because the defendant has already been charged. That's why he's there. He is present, and important rights, for example, his freedom may be lost unless he has an attorney. And that applies to not only arraignment, it applies to the preliminary hearing in a felony case, a trial, of course, and sentencing. So, and any pretrial hearings like motions, for example. Um, Also, a critical stage is considered to be a post-charge, so it's after charging, interrogation, and lineup. So again, if they want to do an interrogation or lineup after the person's been charged, it's a critical stage. Why? A critical stage is the defendant has been charged, and I just mentioned he's been charged. He will be present. He's going to be present at the interrogation, and he'll be present at the lineup, and important rights could be lost unless he has a lawyer. So post-charging interrogation and post-charging lineups are critical stages. And then also sentencing. The person's been convicted, they're going to be sentenced. It's after they've been charged and convicted. So also they're present, and important rights like their freedom can be jeopardized unless they have a lawyer. And also their first direct appeal is considered to be a critical stage. So if you have a lawyer, either you hire one or one is appointed, you can appeal your conviction based on ineffective assistance of counsel. Remember, the Sixth Amendment guarantees the right to effective assistance of counsel, and that means one that is retained or hired by you, or one that is appointed by the court. But a conviction can only be reversed on the grounds of ineffective assistance of counsel if the representation was grossly deficient, and two, there's a reasonable probability of a better outcome, which means acquittal or reduced sentence, if your attorney was basically competent. This is difficult. You really have to show grossly deficient. Negligence isn't enough. So grossly deficient would mean, like at a trial, they didn't participate in the jury selection. They didn't aggressively cross-examine the witnesses. They did not investigate the defendant's claim of alibi or innocence. They didn't call any defense witnesses. They didn't file any motions. It has to be grossly deficient. And then the other hurdle is that you have to show a reasonable probability of a better outcome. So the court's going to look at all the evidence, and if the evidence is overwhelming, fingerprints, DNA, multiple witnesses, then you probably won't get a better outcome even if you have a competent attorney. So you have to show both of those things. Remember, when you hire an attorney or have one appointed, what do you expect that attorney to do for you? A lot of students will say, well, they're going to represent me, or they're going to beat the charges. But practically speaking, what does that mean? What does the attorney have to do? The attorney is going to have to receive all the discovery, all the police reports. They're going to have to read through all of those. They're going to have to go over that with their client. They're going to have to interview their client. They're going to have to interview all the witnesses. They're going to have to look at the physical evidence, the photographs, the diagrams, the physical evidence. They may have to hire experts to look at the physical evidence. They may have to look at the crime lab reports. They may have to hire a private investigator, have private testing of the evidence. There's a lot to do in a criminal case, and it's especially important if you're looking at a death penalty case. That's the most important type of criminal case that I can think of, and so it's very important that you have an attorney that is really rigorous in their preparation and representation of their client. So that all takes time. But it is important that they do that. So you have a right to counsel, but can you waive that right and represent yourself? Sure, that's the flip side of the coin, and that's a case of Ferretta. It's a U.S. Supreme Court case out of 1975 that said a person can waive the right to represent. Strike that. They can waive the right to counsel and represent themselves. A judge has to be very careful when a person asks to represent themselves. If a judge just says, "Oh no, you're not going to do that. I'm denying that. You have a counsel. You have to have an attorney," and denies them the right to represent themselves. If that person's convicted, the appellate court is going to reverse that automatically. The ink won't even dry. It'll just be reversed. It'll be sent right back down to the trial court so the person can represent themselves. So a judge really has to be careful about that. So when a person asks to represent themselves, in a misdemeanor case, typically I allowed it when I was in adult court. On a felony case, where the consequences were more severe, more substantial, I would take more time with the defendant. So I usually had a questionnaire I'd have them fill out, but it went over the person's background, um, general background. If they had background in legal proceedings, it went over the charges, the elements of the charges, the possible defenses that that person has, the maximum time they were looking at. There was a admonition against representing yourself. It talked about the prosecutor being trained. Um, just all those things, and then eventually, then if the person was continued to want to represent themselves, and the court would accept a waiver of the right to counsel and allow them to represent themselves. Um, so you have to grant that request even if it's unwise. And again, if you just deny it, it could be reversible error. So a judge has to be careful about that. So once you have an attorney, can you get rid of your attorney? Can you fire your attorney? Let me tell you about that. So first of all, if you retain or hire a lawyer, that lawyer's like your employee. So if you hire a lawyer, you can fire your lawyer. It's just that simple. The lawyer, he's not your boss. You're the boss. You've hired him, and you can fire your attorney. When you have an appointed lawyer, it's not so easy. You have to make a motion. It's called the Marsden motion, and so the person would make a request to the court, and it comes up different ways. Some are pretty smart. They'll say, "Your Honor, I want to make a Marsden motion," or they'll say, "Your Honor, I don't like my attorney. I want a new attorney," or "Your Honor, can I have someone else?" I mean, they'll say something like that, and then the court will ask the person if they want to have their current counsel relieved and new counsel appointed. If they say yes, then the court will have a hearing. The hearing is just the defendant and the defense attorney and court staff. The prosecution is not present. Why? Because there's going to be a discussion about the case, and that's privileged information, and that information should not be disclosed to the prosecutor. So generally, the court's going to ask the defendant why he wants new counsel. The judge will listen to the defendant, and after that, allow the defense attorney to respond. And then after the the court listens to both sides, the court will make a determination of whether to grant the motion and replace the attorney or to deny the motion. So it will be granted if the court feels that the attorney has been incompetent, or there's been a breakdown in communication between the attorney and the client and they no longer can communicate. Now, if it's denied, then you go back in and you proceed with the criminal case. If it's granted, though, guess what? You have to appoint new attorney, and the new attorney has to get up to speed, which means they have to get all the discovery, interview the client, interview the witnesses, and so on. So if that happens, especially in a big case, what's going to happen? There's going to be a big delay. So you have to, and people don't understand that. Well, why is it taking so long? Well, maybe there's a new attorney that was appointed and they have to prepare for the case. So let's talk about the authority of the attorney. The attorney controls all decisions affecting trial tactics. that are necessary to represent the defendant. So whether to call a particular witness, introduce particular evidence, ob- object to evidence, stipulation to facts, um, all those trial tactics are left to the decision of the attorney. The defendant retains absolute control over his fundamental rights. So, a fundamental right is a right to choose his defense. So, the defendant gets to choose his defense. For example, it might be an alibi. Even if it's unwise to make that choice, it's his choice to make, and the attorney has to represent him and can make decisions regarding tactics. The defendant also gets the right to decide if he's going to testify, if he's going to plead not guilty by reason of insanity, to waive a jury trial, or to plead guilty. So those are fundamental rights. So, and those are all left to the defendant. So, for example, to plead guilty, what happens if a prosecutor makes an offer to the defense attorney? So, for example, the two attorneys are in the hallway and the DA says, "Hey, we got the Smith case next week. I'm going to offer you count one and probation, time served. I'll dismiss the all other charges." Can the defense attorney accept that offer? No, the attorney cannot accept the offer. The defense attorney has to convey the offer to the defendant, and the defendant is the one that decides whether or not to accept or reject the offer. Um, so, of course, when you have a defendant and a defense attorney, most of the time, I won't say all the time, but most of the time, the attorney will work together with the defense attorney on all these issues, and they come to a consensus. There's not typically a lot of fighting that goes on, infighting between the two of them about how to handle the case. Usually, they're discussing the case as a case moving through the process, and they come to some sort of an agreement. So the last area that I want to talk to you about is the Sixth Amendment restrictions on the police. So first of all, the police and the government cannot interfere on the attorney-client relationship. So a couple ways that comes up. So the attorney is representing a defendant, uh, and um, and the can the police officer go to the defendant to interrogate the defendant without his attorney? Well, in the past, the answer was no. But now there's a case that basically allows the officer to go to the defendant, even if he has a appointed lawyer or retained lawyer, to ask the defendant for a statement. But before he can take that statement, he has to advise the defendant of his right to an attorney. And he would do it the same way that he advises a person of their Miranda rights, and then he would take a waiver. And then if the defendant chooses to make a statement, he'll take the statement. Most of the time, a defense attorney, the first thing he tells his client is not to talk to the police, not to say anything to the police ever. And so most of the time, a defendant will say, "No, I'm not going to talk to you." Can police officers record private conversations between the attorney and the defendant? The answer is no. That was recently done down in Orange County, and it caused a lot of problems down there. I haven't really followed the case closely enough to say that the cases were dismissed, but I'll tell you what, that is a violation of the person's Sixth Amendment right to counsel. So officers cannot interfere with that relationships. I had a case, it's an interesting case involving a juvenile where the DA sent a subpoena to the mother to testify against her son. The mother was the victim of a battery by the son. The subpoena from the DA listed the DA's name and phone number. The mother called and said, "Hey, I got this subpoena. What's this all about?" And the attorney says, "Well, your son pled or denied the allegations. We're having a trial." and so you need to be there on this date, and you're going to testify. So they ended the call. Well, after the call, the mom went out and talked to the kid and said, hey, what did they make you an offer, and you need to accept the offer and not go to trial. So when they came back to court, the defense attorneys claimed that his client was denied right to counsel, and claimed that the DA interfered with his client's right to counsel. Of course, the DA denied that, but I had to have it briefed, and there's a motion to dismiss, I believe. So I had him brief it, and then I heard testimony, and I ended up denying it. And the reason why I denied it is because I found there was no interference. The district attorney's office merely sent out a subpoena, which they're obligated to do. They talked to the mother about the case. They were being truthful. They never told the mother or asked the mother to contact the son and tell the son to take the deal. So that was not an order from the DA. And because there was no order from the DA, the mother was not acting on the district attorney's behalf, and therefore there was no interference with right to counsel, and I denied the motion. So it does come up, not very often, but that was one time that I remember that it did. And I wanted to share that with you. So that really concludes all I have to say about right to counsel. Make sure you read the part of the chapter. It's the first part of chapter 8 on right to counsel. The second part of this chapter, they don't really go together, but it's pretrial identification. And we're going to talk about that in next week. To give you a hint, there's only three um, techniques of pretrial identification. There's a show up, that's in the field. There's a photo lineup, which is, as the name implies, photographs of people that are shown to the victim or witness. And then there's what we call an Evans or live lineup, where the person actually appears in person in front of the victim or witness for a lineup procedure. So those are the three. Those are what we're going to talk about next week. Anyway, I hope you're all doing well, staying safe, working hard, and the semester is going well for you. All right. So take care, and I will talk to you soon.